So now we'll turn to the second topic of this privacy lesson on the topic of the email system superhuman. So somewhere around 2019, perhaps it was the year earlier already, I'm not sure, I started noticing that a small number of email messages that I was getting from people I know, mainly people who are in high-tech places in the Bay Area, at the very bottom said, "Sent via superhuman." And it wasn't too long after that I started reading about controversies about this email system superhuman. So what I'd like you to do now, if you haven't already, is to read these two fairly brief articles that are in the reading list about the email system superhuman, and then we'll come back and discuss them. So I'd love to use yet another discussion group to allow you to discuss your reactions about this, but there's a limit to how many of those we're going to do in any one module, and we're actually going to do one more about the right to be forgotten still in this lesson. So I'll just go through a little bit of what you read. A very quick summary of this is that Superhuman was, or is, an email system for what are called power users of email who want various cute shortcuts. And along with that, it's a system that was giving every person what's called a read receipt. So it would tell you when somebody had actually opened your email, and it would also tell you the location, and therein lies the issue. As the articles point out, that's an obvious issue that has personal safety concerns. If, for an example, somebody was trying to stalk a person, they could easily do it by sending them email through Superhuman, and the person at the other end wouldn't realize that the sender was getting that information. So as a small digression, just to repeat something that was explained in the article, how is that done? It's done through the use of something called a tracking pixel, which is an absolutely standard thing that is used on the web in the business of downloading images. So a tracking pixel is a 1-by-1 pixel, which means essentially an invisible pixel, that is inserted into images and that allows the server to download them to your machine. Basically, the tracking pixel is sent back to the server. It gives the server your IP address. And by the way, once it has your IP address, it can easily figure out your location, and that allows the image to be downloaded. In that context, it's not dangerous, and it's considered a standard thing to use. And that's what Superhuman was using to know the location. But what it was doing, it was actually telling the person what that location was. So it's interesting to see what the reactions were. And I'm just quoting a couple things from the article. On the one hand, once the controversy arose, some people reacted with, quote, alarm and concern about the personal safety issues. Some other people reacted with, quote, scorn and derision about the fact that there could be a user, and these were savvy users, who didn't understand that feature. Now, I have to admit, I may not be the most clueful computer scientist in the world, but I am a practicing computer scientist. I didn't know about tracking pixels. Maybe these people did. And for many of those people, the implication was that anybody who was using the system should have understood that implication and accepted that implication. And that's clearly questionable. I thought what was the most classic quote in the article, and it may be the most classic quote of this entire course, was that the initial reaction of the CEO was, quote, "We did not consider bad actors," unquote. If you were going to take one quote from this course and put it up on your wall to remind you what your ethical responsibilities are as a data scientist or any other sort of professional, it would be that we did not consider bad actors, and the fact that you have to consider bad actors. Now, I'm not trying to demean that CEO, or at least not too much, because actually after initial comments like that, he and that company appears to have done the right things. They made read response an opt-in They removed the location information from it, even if you were using it, and they removed the database of locations that they had assembled so that it couldn't be used for ill purposes in the future. But of course, that still leaves the question about whether and how that should have started in the first place. The article, the New Yorker article itself, contains lots of ethical statements by the author. One of the things that I find interesting, particularly in the context of a course like this where we talk about ethical frameworks, is that there's absolutely no basis given by the author for how the author is making those ethical judgments. They're just made. I'm not going to analyze this any further. I think it's a very interesting case and one to be aware of. And as I said, a quote from a CEO to hang on your wall. But I'd suggest that there's three questions that you ask yourself as you think about this a bit more. The first one is, what's your analysis about whether this should have been included? There is not 100% consensus, as you can see, even after the fact. The second one is, what's your basis for that judgment? Is it based on some ethical theory? Is it based on something more than that? And the biggest one by far, and the thing that a course like this is really meant to set you up for, is what would you have done and what should you have done if you were on the product team that was developing Superhuman and knew about this capability, or something analogous to that? Those questions are really the crux of the matter in this course. And they really get back to that hypothetical example that we used in the ethical frameworks about releasing a product before it's fully tested. It's kind of analogous to that. Should you have released this? What would you do if you were getting pressure to release it, or if your boss doesn't accept your argument that you might make that this is unethical? So those are really the issues that we need to be thinking about in the Superhuman case. Is a very nice kind of compact one to think about those issues. So now we're going to turn to the final aspect of this lesson on privacy, a discussion of what's called the right to be forgotten. If you haven't read the New Yorker article that I put in the reading list yet, please do so before proceeding with this video. It's a pretty long article, and you can use your judgment. I think if you read the first parts of it and then maybe just skim the rest, that's likely to be sufficient. Then after you've done that, I'm going to make some comments about the article, but then we're going to have a serious discussion group where you are able to get into a discussion about issues related to the right to be forgotten. So as we begin to discuss the right to be forgotten, it may be helpful to kind of map out some of the variants of cases that one might consider. There's some compelling cases that come up in the article where I think most people at least, would agree that there's good reasons to want to be able to erase what's on the internet. I'll use erase in quotes there, and I'll get back to that in a little bit. So that first example of the gruesome automobile accident photo that was never meant to be posted to the internet, but is probably one of those compelling cases where many of us would agree that it would be nice to remove that. More generally, when private photos are posted without permission, and particularly when they've been taken without permission, we would likely put them in that category as well. But then there are cases that are clearly more on the borderline. For instance, the criminal history of a person that may have happened decades ago and where that person has been an absolutely excellent citizen for many decades since then. Or the one that's talked about in the article about the past financial problems of a person whose finances are no longer an issue. And then finally, as the article points out, there's cases that are far more nuanced. And that is, does this matter if all of a sudden somebody who's been a very private citizen decides to run for a public office? So as the article points out, Europe, through what amounts to essentially a Supreme Court for the European Union, has established the right to be forgotten, a legal right, which I should read. It says, all individuals in the countries within its jurisdiction had the right to prohibit Google from linking to items that were, quote, inadequate, irrelevant, or no longer relevant, or excessive in relation to the purposes for which they were processed and in the light of the time that has elapsed. I've got to admit that as I read that, it sure sounds like legalese, and that actually gets to an interesting aspect of this, that the body that was given the, quote, authority and responsibility to arbitrate this is Google and other vendors, but it really started with Google in this case. So Google was required, or is required, to set up a process to receive requests to remove things from the internet, and then to consider whether to grant those requests or not based on the criteria that I just read. By the way, I just said remove from the internet, and I want to pause on that for a moment. As I think you all understand, it is not possible to literally remove or be sure that you've removed an image or piece of information from the internet, because that would require looking at every server that exists. What you can do, however, is remove its existence from coming up in web browsers. And if you do that, you have come extremely close to removing it from the internet. And so when they say remove from the internet, that's really what they're talking about. The other thing that I should have mentioned is that the law that is the right to be forgotten in the European Union does differentiate. It's not a uniform assessment. It differentiates along axes, including whether the individual is a, quote, public or private individual. It differentiates about how reliable the information that is posted is in the first place. And so there are various criteria that have to be looked at. I think the other thing that is particularly interesting is that the article points out that whether you believe this is the correct approach or not really depends on how you weigh two fundamental properties. One of them is the right to privacy, and the other is the right to free speech. And how that is done, how those are weighed, may vary from place to place. So I'm purposely not going to try to make any judgment on this right now, because the next thing we're going to do is ask you to do that. So at this point, we're going to enter into what I hope will be a slightly more extensive discussion group than we've had up until this point, where I'd like you to consider 3 questions, and they'll be written on the screen and in the prompt as well. The first is, do you feel that there should be a right to be forgotten in the country in which you reside? There may obviously be differences in how different countries look at it, but I'm just going to leave the question at that one. The second one, which is related to that, is do you think that this should be a universal assessment, or do you think it should vary between different countries or between different regions of the world? And then the third question is essentially why. That is, what is the basis for your opinions, whether that basis is ethical frameworks or anything else? So I'd like you to use this discussion prompt to both enter some of your own opinions on each of those questions, and then comment on at least one other person's opinions on each of those questions before coming back to this lesson. I hope you found that interesting. It's certainly one of the deeper and more nuanced questions that we'll probably deal with in this course, and that our field is dealing with now when we look at ethical issues in data science. I'm going to conclude with a few general remarks. The first is I'd like to share with you some of the comments that an in-person class made when we had the same discussion in a computing ethics course that I was teaching at the University of Colorado. I can't in real time see what you're saying in the discussion group, so I'm relying on that instead. So one comment that the students made was that they questioned why Google was the arbiter. They're kind of the judge and jury in some sense, as opposed to some other body being the arbiter. And that point, as you may have seen, was brought up in the article itself. A second point that the class made was to just reinforce that this is not a one-size-fits-all, that there are a variety of issues or attributes of a particular case that might influence whether something should be removed or not, including whether you're dealing with a public or private figure, perhaps what the age of the person was when the information question was posted, and how long ago that incident happened. The other thing that they pointed out, and this is also pointed out in the article, is that some of these cases are dealt with by laws that exist already. Laws, for instance, about copyright or laws about precluding pornography. So two final and fairly important and high-level comments that this discussion brings up. The first one, and this is still talking about the right to be forgotten, is what our ethical frameworks say. Now, the article already kind of focuses on that because it talks about two potentially conflicting values, the right to privacy and the right to free speech. So let's say, for instance, we were looking at this from a Kantian point of view. Are each of those categorical imperatives? There's no precise statement of what categorical imperatives are or can be, but it seems quite plausible that both the right to privacy and the right to free speech could be considered categorical imperatives. And if so, what this discussion in the article points out is that they're in conflict. So how do we weigh which one comes out ahead when they're in conflict? That's really the crux of the matter of why this may be looked at differently in different areas. And that, in turn, gets us to the final point, and a really important one, which is the concept of cultural relativism. The idea that the judgments on moral and ethical issues may be different in different societies and in different parts of the world. The article, for instance, points out the fact that Europe, interestingly, due to what's fairly recent history by historian terms, the history of the middle of the 20th century under both fascist and communist rules, came to value the right to privacy quite a bit more than the right to free speech. Whereas in the United States, those value weightings are different. And in some places in Asia, as an example, China, they're different again. Those sorts of discussions would get us into even loftier philosophical and ethical discussions than we may get into in this course. But on a very practical scale, they're highly relevant to your careers as professionals. Why? Because you're going to be producing products that are used throughout the world. And even if you're not dealing with ethical issues, you will still be having to understand a variety of cultures and how a product may play differently in those differing cultures. And in some cases, that may include ethical issues. So this has been a pretty wide-ranging conversation about various issues that come up in privacy in the world of big data and data science. I hope you found it as interesting as I have. And our next lesson will be on security.